Okay, so this third panel is on taxation, economic impacts, and environmental and social justice. And we have four great presentations. We have five presenters, but four presentations. And we're going to be going slightly out of order from what you see in the program, because in our planning call, we felt there were really some synergies in a certain direction that that paper should go in. And so that's how they'll go. So I'll just introduce all the panelists, and then I will turn it over to them. They're each going to be speaking for 12 minutes so that we have plenty of time for questions and comments at the end. So the person who will be speaking first is Jack Hornickel. He serves as the staff attorney in the Food and Farm Business Law Clinic at the Elisabeth Haub School of Law at Pace University. He joined the clinic in 2021, and the clinic provides transactional legal services to small farms, food and beverage entrepreneurs, and nonprofit organizations seeking to improve the food system. He focuses his services on intergenerational farm succession, land use, conservation, and land access. Previously, Jack provided pro bono representation in small business services to farmers selling in the green market, the largest network of urban farmers markets in the country. And he is a 2015 alum of Vermont Law School. Then after Jack, Alice Caswan will be speaking, and she's a professor of law at the University of San Francisco School of Law. Her scholarship focuses on climate justice and the ways that climate planning, climate funding strategies, regulatory mechanisms, and market mechanisms impact social justice. And following Alice, we will have Colin and Quentin together. So Colin Lingle holds a PhD in political communication from the University of Washington and an MA in mass communication and journalism from the University of Colorado at Boulder. His areas of focus include political identity, digital media, and democratic activism. Building on his academic work, he consults on media strategies for environmental and civic organizations. And Quentin Thorens is a Swiss attorney registered with the Geneva Bar and admitted to practice throughout Switzerland. His practice focuses on inheritance disputes and estate planning. He's currently pursuing an LLM at the NYU School of Law. And batting cleanup will be Sam Brunson. Sam is an associate dean for academic affairs and Georgia Reithal professor of law at the Loyola University School of Law in Chicago. He researches and writes about the federal income tax and nonprofit organizations. Much of his research deals with the intersection of religion and the tax system, and he has a very interesting new book that just came out that maybe he'll mention for us. He also researches how the federal income tax both regulates and fails to regulate tax-exempt organizations. And his most recent book, as I said, Between the Temple and the Tax Collector, was published in February. So I will turn it over to Jack to start us out. And you can come up here, stay there. Yeah.
Thank you, Tony, and thank you, PELR, and the ATPI for organizing this conference. Good to see everybody here today. Thank you for the privilege of being the first speaker after lunch. I'll try to be animated and describe my research and my proposal to you with enthusiasm. I did not have time to prepare slides for this, so I apologize in advance, because I'm actually very, I think what is very motivating to work in agriculture is to be able to see beautiful landscapes, and I deprived you of that in this moment, so I apologize in advance, but I'll be sure to slip some into my submission for the journal. So a disclaimer, I have no background in economics. Someone was referring to Econ 101. I didn't take Econ 101. I'm not a tax professional. My legal practice has focused on serving small farm businesses. And in that service, one of my main service areas is drafting commercial leases for tenants to access farmland. And in that negotiation, the eligibility and qualification for the agricultural tax assessment is a significant negotiation point in reaching a deal. So I'll be describing that program. That's the program. My study of that program is the sort of heart of my research and proposal here today. I'm going to lead you to what that program is and does, and why New York could amend it to better reflect the carbon sequestering properties of soil in the state. But I just wanted to disclose that I'll probably, someone was saying leakage earlier. I'm not sure what that means. I might need you all to catch me up on some of the economic terms that I'm stumbling over during the cocktail hour. So appreciate you if you could catch me up when we have the time. So I'll be speaking about property taxes. I think a lot of what we've been hearing about today have been income tax related and credits and maybe also excise taxes, tariffs. I'm not sure where to sort of fit that in. But property taxes across the country are the revenue generating tool of local governments to provide essential services, schools, roads, bridges, emergency services, et cetera. They are assessed against the value of property, and they are paid annually. In comparison to, say, income taxes or excise taxes, they don't relate to an event or an activity. They are just an encumbrance on ownership of an asset, of real property. So in a sense, they're inevitable. It's a bit of a hot potato. When you close on a house, you pay the prorated taxes that owner has already paid for that year, and there's a shift of that expense. But taxes are always being paid on an annual cycle, regardless of sort of events or activities. There's the qualification to that is that properties are taxed differently based on their status. If you are a low-income homeowner, you might receive a different tax rate. If you are, and I'll tell you about the tax rates that farmers receive in this state. But generally speaking, it's a little bit of a different tax perspective, how both what the revenue is used for, who is collecting it, and how important it is to their civic services, and what it's assessed against. It's assessed against the ownership of land. There is also a constitutional basis for uniformity of property taxation, just as there would be for one person, one vote. There's sort of an equality of taxation that is the goal of each state. The exception to that is that there can be different tax statuses based on classes of property. Each state, in reaction to the development, the urbanization and suburbanization of the country after World War II, passed what's called a use value taxation assessment program. The first one was passed in Maryland in 1957. The counties surrounding DC were experiencing an explosive growth of development. And as a tool to slow that development and preserve rural and open space, they passed the first use value taxation assessment. Now all 50 states have some version of this. New York's is called the agricultural tax assessment. But all 50 states have some version of this. And the general scheme is that you enroll a property based on its status as being open and used either for farming or forestry or range or something like that, open space. And for doing that, if you meet some eligibility, you receive a lower tax bill when you pay your local property taxes. So, and each program operates a little differently. They each have different eligibility requirements, enrollment steps, forms, and all that. And they also all have some kind of penalty, or most of them have some kind of penalty, that if you're enrolled in this program, getting a lower tax rate for a number of years, and then you go and develop that property, you remove it from being open space, working land, and you turn it into a shopping mall, there's a penalty, a rollback of the taxes that you had saved during the period when it was enrolled. So they all generally have that feature. So we're now over 50 years on this national wave of this tax system. And the results are pretty mixed. I think that most would agree that this tax program did not stop development, right? And some would also argue that it hardly incentivizes farming. It's just another program that provides a marginal benefit to property owners who may or may not be legitimate farmers. And there's a whole issue around the eligibility for these programs and how easy they are to meet. I'll tell you a couple of quick examples around that. In Ohio, 60% of the land is enrolled in their current agricultural use valuation, but undoubtedly 60% of Ohio's land is not actively farmed. I can tell you from my personal experience growing up in Ohio, we had an 18-acre parcel. Our house was in the woods. It was not a forest for forest purposes. It was just a scrappy woods. And as a teenager, I went out and I cut grapevine, and that qualified our property to a lower tax assessment because we were engaging in forestry practices. Right? It's very easy to enroll properties in this program and get a tax deduction. They're popular for that reason, and I'll speak to what I think the political feasibility of changing any of this is on that basis. In New Jersey, you only need 3 acres, and you only need to earn $500 from farming in order to get a lower tax rate. So it's a very low threshold. They did amend it recently to $1,000, right? But $1,000 is hardly a farm operation. So New York's program, I'll skip all the eligibility. It is tighter than both Ohio and New Jersey. It's important to recognize that 20% of New York's landmass is farmland, that soil as the basis of farming has an incredible carbon sequestering capacity. The science on this is still being developed, but the capacity in New York, being a large agricultural state, is immense to sequester carbon. And I'll skip ahead to how the program works and my proposal to change it to get to the point. But I think New York has an opportunity to adjust this program in order to incentivize carbon sequestering practices on farms that are probably already enrolled in this program anyway and receiving the benefit. So what is the value of farmland as farm, right? It's not its market potential as a shopping mall. It's not its development potential, but how is the farming potential calculated? Here's where the economists can educate me. It uses an income capitalization approach. So you take the potential to make money farming, and then you capture that in a current market value. And this math is done for this program. I was reading it yesterday. Looks like it was printed on a dot matrix printer and then scanned. It has not been updated since 1980, and it's fascinating. It's macroeconomic and agricultural in nature, so it's pretty cool and nerdy to read. But basically, they take a formula for a common hay and corn rotation, which is these are just commodity crops, right? And determine the most money that someone could make using that rotation, factoring in flooding, the pH of soil, and other sort of factors like that, minimum erosion qualities, like this whole analysis, and then assign a value based on each soil type. And you can go, I show my students in the seminar, you can go on the USDA website, pull up the map, look at every soil that exists in the country on like a square foot basis. It's an incredible data set. So that data set, combined with this quantification of how much money you could make growing corn, is how the value is set. And in my opinion, and that was set, 1980, in my opinion, that's outdated, right? If you have a farmer that's growing a mixed vegetable enterprise, they're growing human food, there's a completely different micronutrient exchange happening, including carbon in that cycle, than what corn might be doing. So the tax value that person is receiving is irrespective of what their actual practices are. All they need to do is check a box that says they earn $10,000 a year. So the program doesn't match what farmers are actually growing. And even one step further, it doesn't match the carbon sequestering qualities of that soil type. So that's what I propose, that we look at ways to amend the agricultural assessment program, either through regulation or statute, to add some little bonus for carbon sequestering capacity of the soils on a particular farm. And then, you have this sort of second step of like, well, how do you verify that those activities are actually happening? And there's a number of activities that could qualify for this. The basic ones are just cover cropping. That's planting something to keep the soil from being bare, and reducing tillage. People have been adopting these practices for other environmental reasons for over 100 years. The Dust Bowl was a tillage problem, an erosion problem. So we've been addressing this through agricultural technology for the last century, but we're also realizing, it actually really helps with the carbon cycle as well. So that's my proposal. I want to speak to why I think it's politically feasible, because New York State has a mandate under the Climate Leadership and Community Protection Act to increase these practices and set a price for carbon and really reckon with this cycle and how it relates to farming and forestry. There's been another bill that created soil research programs throughout the state. And there's a bill in the Senate right now that would create a income tax credit for farmers that were engaging in some kind of regenerative agriculture, which is probably loosely defined. So I think the momentum is there. I think it's possible. And I also think that there's a genuine criticism of all these programs state by state, that they're kind of just for property owners. They're not really for working lands. They don't really relate that much to ecosystem services or ecology, and that they could all use a refresh. And I think it might be possible, and I look forward to talking more about it from the chair.
Alice is up next.
Thank you. I'm really appreciate the invitation to be here. I'm learning so much throughout the day. It's great to hang out with tax people, which is not it's not my usual crowd. So again, I'm learning a lot and really appreciating it. So let's see, to get to my PowerPoint, I will do that. That's amazing. Wow. You're tech people, really impressed. Okay. So I'm here again on our social justice panel. And I just want to note that there's so much we want to accomplish as we think about a green transition, as a transition to a clean energy economy. We want to help people who are currently disadvantaged. We want to be sure that those who are now dependent on fossil fuels have a transition to a future. And we have a lot of different policy options at hand, right? They're the emissions taxes and tax credits that we have as the focus of our discussion today, as well as many other prescriptive policies. And I want to talk just a little about, how do we want to think about that mix between that sort of tax side of policy and then more prescriptive policies in contrast. So I'm going to be looking, sort of lumping together to some degree, or primarily focusing on, I should say, not always lumping together, emissions taxes and tax credits, right, on the one hand, and more prescriptive regulation on the other, looking across these various areas. So let's talk about a key social justice aspect of this. And one is just thinking about the multidimensional character of a clean energy transition, right? This isn't just like a narrow environmental problem. This is a really society-wide problem that we're addressing, or that we're confronting when we look at climate change and all that it impacts. So when we think about emission taxes, right, and here I'm focusing on the emissions tax, it works generally along one dimension, right? There are economists who talk about optimal, right? What is optimal? But generally they're looking at what is optimal from the standpoint of reducing emissions of carbon dioxide, right? What is the best and fastest and cheapest way to reduce carbon dioxide? But because a clean energy transition is going to affect multi-dimensions of our society, there are things we could miss. There are other dimensions that we may not be considering if what we're doing is just optimizing for reductions of carbon dioxide, as important as that is, right? I don't want to minimize that. So what are some of the other dimensions? Probably the one that gets the most attention from an environmental justice perspective is, what about co-pollutant emissions, right? Every time you're emitting carbon, you're emitting some other kind of a co-pollutant that has more immediate public health effects. And we know those are very unequally distributed. So while a tax, for example, an emissions tax can create a general incentive to reduce greenhouse gases, we don't actually know which facilities will choose at a given time to actually reduce emissions, and which ones will say, no, I'm going to keep going and pay the tax. The little dollar signs, right, coming out there. I'm just going to pay the tax here. And if we find that facilities are paying the tax in areas that are where there are high concentrations of pollution, those areas are just not going to get this benefits of the clean transition that we hope for, right? So we don't really know where the benefits of reducing co-pollutants are going to fall. And that's been a big concern in the environmental justice community about all of the market mechanisms, whether cap and trade or taxes. And we worry even that in some cases, right, the tax may be at a level that ends up incentivizing like natural gas, right? Or maybe a biofuels plant that has co-pollutant consequences, rather than incentivizing maybe the wind and solar that we would want to achieve. And then, as with many other policies, when you apply a carbon tax and say, go do your magic, right, out there, if that were the only policy we were to adopt, we wouldn't be dealing with some other very important dimensions of our transition, like what's going to happen to the workers who were in fossil fuel, right? The tax itself, at least alone, would not deal with that. If we think about tax credits rather than carbon taxes, right? One imposing a charge, one being something that you give out. I think those actually could accomplish a lot of social justice goals. And a lot of that is about how you tailor the tax credits, right? So you can have eligibility criteria like for tribes. for low-income households, for small businesses, for truck fleets that are, 10 trucks or less, whatever it might be, you can set up eligibility criteria for tax credits that could direct them, or you could really specify the types of eligible projects, right? You could say, well, they're available for renewable energy, but not maybe for a biofuel project, right? Or you could give higher tax credits in targeted priority areas. In fact, the Inflation Reduction Act does a fair amount of this, right? It says tax credits for renewable energy development, but more of a tax credit if it's in a disadvantaged or environmental justice community, and more of an advantage if it's in what we call an energy community, one that was historically dependent on fossil fuels. So you could stack those up, right? So I think tax credits actually provide, or have at least shown that they've provided some of these more multidimensional benefits than at least a standard single carbon price would. There's also a participatory side to environmental justice. We want to think about what's the public role in deciding what our transition path will be, right? There are many different ways to transition. So how are we going to do it, and who's going to decide? So if we look at emission taxes, of course, there's some governmental role. We have to set the tax and figure out who's subject to it. And we have utility regulation that provides a bunch of other constraints on the power sector. But ultimately, it is going to be the private sector that plays the dominant role in deciding strategy, right? Different entities in different sectors will decide how they want to respond to the tax, which is both, again, one of the benefits, that flexibility and that freedom, right? But if we think about what's the public's role in deciding on clean energy transition strategies, it's much more minimal in a carbon tax than it is with more prescriptive measures, where you have efforts to set up particular goals and targets in very specific sectors. You come up with these through legislative and rulemaking processes, never perfect, right? But at least there's some opportunities for a degree of governmental accountability and in some cases, public engagement. And in many cases, you have actually planning processes, right? We have cities, states, federal agencies, others saying, what is it going to look like? What should we do? And those planning processes, what do I have? 5 minutes. All right. And those can be interdisciplinary and include the public in this context. So I think we have a real contrast between a single tax and more prescriptive measures in kind of who ends up controlling decision-making processes. And then with tax credits, again, if you have a legislative process or an agency process that's doing a lot of tailoring around who should get the tax credits, then we do have some public participation in the process of deciding what we want to prioritize in terms of providing subsidies. As we noted when we talked a moment ago about multiple dimensions. And then I'm also going to note that people can vote with their feet to some degree with a tax credit, right? So I'm acknowledging, right, when you say who participates, right? If you want to take advantage of a tax credit, then you vote with your feet, if this is a consumer tax credit or an industry one. I also want to talk a little bit about practical limitations. I'm actually moving slightly outside the scope of social justice here, but what are some of the things around these mechanisms? So one of the concerns around taxes and other kinds of market mechanisms is they provide incentives, right? They nudge, as we say, but they don't plan. Both tax credits and taxes nudge, but don't plan. And in many contexts, we're really going to need a lot of planning to be able to effectively do a clean transition, right? Taxes can't coordinate infrastructure or reliability or those challenges around how we're going to integrate, how much of distributed generation into a grid, right? If that's what we want to do, or even think about the role of distributed generation. Do we want things to be distributed? Or do we want them centralized? What's the role of utilities going to be? There's a lot to energy policy that goes beyond setting a price and letting the market do the work. Also, if we want to make a transition and make sure that all sectors are really engaging in that transition to clean energy, again, a tax, an emissions tax or tax credits can't control who's actually making the transition and who's not. This is a chart from California's cap and trade program, but it shows, some sectors doing a lot and some not, industry not doing it, right? Well, how do we make sure it's really happening? A carbon price won't necessarily tell us who's taking steps and who's not. And when we turn to more localized issues, and a lot of environmental justice is about what happens at a localized level, a lot of things we need in a clean transition really require not just that big scale coordination that I was talking about, about the grid, but local coordination. So you get the car, but do you have a place or a way to charge it? What about public transit development? Instead of individual cars, we're just going to put out tax credits for cars, but how's that going to fit into what our vision is for the future of transportation or even of land use, right? That is more sustainable in the long term. The tax credits, tax prices are not resolving some of those critical questions. Pricing, right, is also a big issue. A price could be too low to create a sufficient incentive because it's politically difficult to make them high enough, right? There's a tiny price and there's climate change, right? But as we talked about earlier, if the price is set too high, we can have social justice implications. Now that arises for all kinds of measures. I don't want to say it's only a tax problem, but it's something that's going to require attention. Again, it can't just be a market solution where it'll magically resolve those potential regressive effects. For tax credits, there are various issues around whether they're available to people who don't earn enough to pay taxes. The typical tax credit you get only when you've paid, rather than only when you pay taxes, not when you need to make the expenditure. And again, the Biden administration tried to deal with this, but that's how they work. And a lot of people can't pay the money up front. People who need an item, often the tax credit's just not enough. So we need to think about something more. Political value of a broader vision. I think as we've already discussed, emission taxes, they're not pretty to look at. They're like taxes, credits, ooh, money, on the table. So I think they are more compelling. That's probably why we saw the IRA succeed and the cap and trade legislation from a decade earlier not. All that said, before I close, I do think carbon pricing is essential. I think we need a carbon price because we need belts and suspenders, if you're wondering about that picture. We need it as a backup. We need it as a gap filler when other kinds of prescriptive measures aren't working. We need the revenue that they bring to do all the things we're talking about. And I think we're going to need tax credits as well as rebates and grants, because we're not going to have a clean transition unless we help people who can't afford to do it themselves pay for it. So somewhere in there, we got to get the money out and not just impose a tax. There is no silver bullet. I talk about, the social justice implications of taxes and tax credits and some of the drawbacks, but really we're gonna need it all. And thank you.
Yeah, they're not designed for this.
So next we have Colin and Quentin presenting together.
So it is a real pleasure to be with you. Thank you very much. Thanks to ATPI, to the Law Review, to our fellow presenters who are already raising such interesting ideas, and to Professor Infanti for steering us. As this conference was taking shape, Professor Bridget Crawford saw an opportunity to put together sort of an interesting, unusual team. I am the social science interloper here today, and I will be back a little later to speak to the methodology to our madness. But in the meantime, you are in very competent legal scholarship hands with my distinguished colleague, Quentin Thornton.
So hello, everyone. So we had the idea of doing a comparative analysis of intergenerational equity, that is equity between the current generations and the ones who come, both in tax and environmental discourse across America and Europe. So how did we get this idea? Recently, we've seen a growing number of cases filed by citizens both in America and Europe, suing their states, challenging their action or inaction in the climate crisis. And so in the US, we have the most famous case, which is Juliana versus the United States, where you have 21 young children who sued the federal government, challenging their inaction and their encouraging even of burning fossil fuels. So as you all know, this was dismissed by the Ninth Circuit. But in Europe, we had more successful cases, both at the national level and the international level. So first in Germany, for example, the German Constitutional Court had a very interesting decision stating that the government should review its climate policy because they were violating rights of the future generations. But the most important case here for us, and the case which is the basis of our research, is the European Court of Human Rights decision in the Verein Klima Seniorinnen versus Switzerland. So it's an association of older ladies who sued Switzerland, stating that the weak climate policy was indeed violating their right to life and health. And so the ECHR ruled in their favor. And what is extremely interesting for us is that throughout this extremely long decision, it's almost 300 pages, we find the concept of intergenerational equity from the beginning to the end in different contexts. So we don't have the text, but I will read it for you. So, no, so I will read it for you. An example of what the court said in its judgment is that the special feature of climate change as a common concern of humankind and the necessity of promoting intergenerational burden sharing, that's a term they use in this context, speak in favor of recognizing the standing of associations before the court in climate change cases. So the court basically finds that associations in certain cases can sue on the basis of, in part, intergenerational equity. And the second example of still that judgment is this one: to avoid disproportionate burden on future generations, immediate action needs to be taken and adequate intermediate reduction goals must be set. And this is said in the paragraph talking about the state's positive obligation. So this is for environment. We saw that we have intergenerational equity discourse in environmental, in the environmental talks in Europe, in several courts in Europe, but not in America. And what we knew at that point was that the intergenerational equity talk was very present in the tax policy everywhere, in America and in Europe. And so this is an example of Professor Kotlikoff saying that the US fiscal gap is 211 trillion. It grew by 6 trillion last year alone. We're totally screwed only if we refuse to make the radical reforms needed to end our fiscal child abuse. Once and for all, what's needed is generational balance, equity between the nows and the laters. We only get this by eliminating the fiscal gaps. So with this on our hands, the environmental side and the tax side, we decided that we wanted to see how this was treated in the public discourse, and especially in the media in Europe and in the United States. And Colin will explain what we did.
Thank you, sir. I'll take that. So we did check this presentation before we came, and every slide was beautiful and perfect. And now the gremlins have taken over. We took the concept of intergenerational equity and translated it. So we used content analysis methodology, which I will touch on in a little bit of detail, but we wanted to look at media discourses in different domains. And because we are a slightly unusual team, we have a ringer who can help us read French and German newspapers. I was brought in to do some of the content analysis methodology. We have had an interesting time looking at different contexts for where this discourse appears. So we looked at these different domains, and I cannot tell you how frustrating it is not to have the text. You would really like to see text here, wouldn't you?
It is very small, but it is there.
I can see it.
That is so crazy. So here's what we did. We went and looked for several terms, including intergenerational equity. We also did a translation to look for the term future generations. We had several other sort of more technical terms. Far and away, future generations stood out as the organizing principle. Makes sense, it's sort of common language, but how is this actually working? We did, I believe, Quentin collected over 1,000 articles with the search term. We cleaned the data, we boiled it down. We've coded 3 of our 4 data sets, 2 newspapers in each region. And so we're currently comparing US and continental Europe. We'll be adding UK papers to that as well. So we saw about 200 articles in the US and about 150 in the continental Europe data sets so far. So we have about 350 articles that we're looking at. And what we did was we looked for future generations. We did a search, and then we used this content analysis method, which tells us both about raw numbers, which are interesting, but more importantly, they tell us about patterns. And patterns can give us insights to what's going on. So we, based on what we were seeing in environmental and tax and fiscal policy, we were able to basically count up how much we saw as a percentage, and then also to generate some subcategories that we were seeing. So this is an illustration of the kind of data that we can get from doing this side-by-side comparison. So we have not crunched all our numbers, and as I say, the Brits are stragglers. But here's an example of what we can do. We can look at how many references to future generations are brought up in an environmental context. How many are brought up in a tax and fiscal policy context? And we provide very specific definitions of what that means, what's in and outside of that. What is interesting here is that there is significant parity between the environment separately and tax and fiscal separately. And this follows common media theory saying journalism will function the same in established Western democracies. We do see some difference over here where references refer to both, where there is linkage. And I should note at this point that we have not yet run the statistical tests to tell us if these percentages are real or if they're just an effect in the data. But we will be doing that, and we will be slicing and dicing and looking at other contexts. So this doesn't necessarily tell us anything definitive, but what it does do is give us a thread to pull, and it gives us an empirically grounded reason to consider what it might mean. So in terms of conclusions, we can say that there are significant percentages of these future generations mentions that relate to environment and tax and policy. They are very common. They are the most common. We see similar rates of usage, but maybe up to twice as much linkage in the continental version. This becomes an opportunity for policymakers to use this language to build a bridge between environmental policy and tax policy. So you can combine these ideas. There is an opportunity here to create a linkage discursively to help persuade lawmakers and to help bring more efficacious power to climate activists and climate discourses. So we are pointing that direction, and we look forward to seeing all of the papers in the law review down the road. Thank you very much.
Okay, so because Tony was kind enough to mention that I had a book just come out, I do want to mention that he has a book coming out in the very near future. And I mean, I think you should read both of them, but if you read just one, you should go with his. So 1976 was a propitious year, not just because it was the 200th anniversary of the United States, not just because it's the year I was born, not even just because the Brecker brothers released an excellent record that year, but that year, the US government, the federal government, blessed two types of tax-exempt organizations. In 1976, we had official statements that organizations that promote amateur athletics and environmental organizations could qualify under Section 501c3. Now, 501c3, when I got into this, into academia, I was told never mention code numbers because you'll lose half your audience. But I think 501c3 is probably the exception to that. Just as a quick reminder of what it means. 501c3 is for certain charitable tax-exempt organizations, and it provides a dual benefit to those organizations. The first is they're exempt from tax. They don't have to pay taxes on the vast majority of their income. The second benefit it provides is the deductibility of donations to those organizations. In other words, at least certain donors who qualify to make donations get a federally subsidized donation. They get to deduct the amount of donation that they make. There are a bunch of things that an organization has to do to qualify as a 501c3 organization. They have limits on the amount of political participation they can do. They have a non-inurement rule, that is, they can't distribute their profits to benefit individuals. And they have to be organized and operated for an exempt purpose. Under current law, there are 7 exempt purposes. And if I had gotten my act together and put together slides, this would be the one slide I would have. So if you have your phone open, you can go to 501c3, but I will also tell you what the 7 exempt purposes are. The first 3 are charitable, religious, or educational organizations. Those have been exempt since at least 1894. They weren't listed in the Civil War federal income tax because the Civil War federal income tax didn't tax corporations other than, I think, insurance companies and maybe banks. In 1913, we added organizations that had scientific purposes. In 1918, we added organizations organized for the prevention of cruelty to children and animals, which seems like a good thing. 1921, we added literary organizations. 1954, so a big gap, we added organizations created for the testing for public safety. That one's really interesting, if a little bit outside the scope of this talk. It seems to have been done entirely for a group called Underwriters Laboratories Incorporated. And then 1976, we had amateur athletics added. So statutorily, if organizations like my kids climb in USA Climbing, it's a tax exempt organization. The NCAA, my daughter, I'm gonna be a proud dad for a minute, she is on the rowing team at Fordham. So NCAA is also a tax exempt organization. Environmental organizations, however, have never been granted an explicit express exemption. And yet we have a number of exempt environmental organizations. I led off saying that in 1976, the federal government said environmental organizations are exempt. And in fact, since at least the 1960s, the government has granted exemption to environmental organizations. But they're exempt not because they're environmental, but because they fit within one of the 7 enumerated categories. Specifically, through revenue rulings, the IRS has granted tax exempt status to some organizations because they're educational. For instance, they let people come in and look at nature, engage with nature. Others because they're charitable. They fit under the charitable thing because preserving and protecting land and the environment is considered, for the general public, is considered a charitable purpose. And as I talk about this, it's worth noting that prior to 1976, some amateur athletic organizations were also exempt from tax. if specifically they were related to an educational institution, which seems like kind of a bad differentiation to me. If the NCAA can be exempt from tax, but USA Climbing or AYSO or some organization that's not associated with an educational organization can't. 1976, Congress fixed that. So the purpose of the article that I have is essentially to say that environmental purposes should become the 8th express purpose in 501c3. And I have a couple reasons for that. And I also guess I should point out that whether environmental organizations qualify from a substantive purpose, whether they qualify as exempt because they're charitable or educational, or because they have an express exemption category, doesn't make a difference. They're still exempt from tax. Donors still can deduct their donations. And yet I think there are at least 2 compelling reasons why we should create this new category. And the first is that is a practical purpose. Revenue rulings and private letter rulings that provide for the exemption of environmental organizations are great, but the Supreme Court has recognized the IRS can revoke those. The IRS doesn't have to grant those. And for better or worse, more for worse, the environment has been a culture war touch point since when I wrote this, I said at least the 1990s, because that's about when I became a teenager and was aware of culture wars. But I've been told that the culture war aspect of the environment goes back much further. So as a culture war target, it is at least possible without any express statutory exemption that environmental organizations going forward, the IRS will decide they aren't charitable or they aren't educational. There's nothing that says specifically that an environmental organization has to qualify as tax exempt. Now, frankly, I don't foresee a world in which the IRS starts revoking the exemption of environmental organizations because the administration has decided that no, that's not charitable. But on the other hand, we have a Trump administration. So every promise that I've made to my wife and my kids, it turns out, has not really necessarily happened. In fact, this administration has shown a particular interest in causing executive branches, administrative branches like the IRS to do what they want it to do. And even if this administration doesn't end up targeting this, as long as it's just something that is through revenue rulings and through charitable, a future administration could. However, if the legislature were to add this 8th category, that provides a lot more protection. That means that there is an it's not just within the whims of the administration whether or not it qualifies as charitable. So legislating an enumerated purpose would solve that first problem. But there's a second reason that I think it's important, which is, as we're all gathered here undoubtedly agree, the environment is important. And the tax law is a revenue raising provision. But as Genevieve pointed out, and as Bridget pointed out earlier this morning, it does more than that. The tax law, among other things, can be expressive. So Bridget said that the law changes behavior, but the law can also change attitudes. So one example from the first book that I wrote, I looked at the Church of Scientology. The Church of Scientology launched something like a 20-year war of attrition to get tax exempt status. When it finally got tax exempt status does not mean that the government approves of what we do. We know that. There are white nationalist groups that are exempt from taxation. It isn't a government seal of approval, but popularly and rhetorically, it does kind of function as a seal of approval, even if legally and substantively it's not. So Scientology, it took its exemption and it used its exemption in other countries to say, hey, we are a legitimate religion. The ability and the desire and the willingness of Congress to say environmental purposes are important enough that we're going to put them in our express list, our limited express list of exempt purposes, sends a message. It says, this isn't just charitable, this is important enough that we legislated it. So there is a substantive legal reason why we might want to add it. There is also an expressive reason. It's the tax law speaking to the public, saying this is something important, something that you should take purpose. You should take as being important. Now, one of the big disadvantages to this proposal is it requires Congress to actually function. But one of the advantages is it is low or no cost, because under current law, environmental organizations already qualify. If we add an express qualification, yes, that prevents the administration, a future administration, from removing it from tax exempt status, but it doesn't impose any current cost based on what we do right now. When I presented this to my faculty, one of my faculty members asked, why focus on environmental organizations? Why not other organizations? And the quick answer is, this is a conference about environmental stuff. But I mean, I can go beyond that. And I have two reasons to go beyond that. One is environmental protection is ultimately an existential need. It is tremendously important. And my other is 7 isn't a magic number. 8 isn't a magic number. There may be other worthy purposes that should also be included in 501c3. I have no problem with that. It's different, and it's always fun to try and convince people that tax exempt and nonprofit are two different things. They are. But just because I'm going to conflate them right now, in Illinois, there are 33 different purposes that a nonprofit organization can be organized for. There's no reason that you can't expressly create more if you have other worthy causes. And finally, a definition. The definition that I would choose to go with, at least initially, is fairly broad. It would be to preserve and protect the natural environment for the benefit of the public. And I take that from the IRS's revenue rules. I'm not sold on that, but I think that roughly captures what I wanted to talk about. So thank you all very much.